So today we look at our second last topic, which is topic 15. This topic number 15 has several things. There is something called receivership. There is something called administration. There is something called dissolution. And there is something called liquidation. Those are the four things that we will seek to look at. So let's start with the first one, receivership. Receivership. Receivership, and we write that receivership entails an order. Receivership entails an order or a directive. An order or a directive where all the properties and affairs of an institution, properties and affairs of an institution are placed in the dominion, and control of an independent person known as a receiver. An independent person known as a receiver. Full stop. It is used by secured creditors. It is used by secured creditors to recover their money. Full stop. Shareholders can also use a receiver. Shareholders can also use a receiver to complete a project. Or to liquidate some assets, or to sell a business, So basically, that is what we call a receivership. And we are saying it is where there is a directive, obviously that is coming from the court, whereby the affairs and all the properties of an organization are now given to the control of an individual who is known as a receiver. And it is mostly done by creditors when they want to recover their money, or even shareholders if they want to liquidate the business, or rather the assets, or maybe there is a project that has been incomplete for long, or they want to sell the business. So in that case, you require a receiver. Let's look at duties and powers of a receiver. Duties and powers of a receiver. Duties and powers of a receiver. One, investigate why a company has failed. Number one is investigate why a company has failed. Number two, investigate the promotion, formation, business decisions, and affairs of the company. Number three, convene separate meetings. Of the company's creditors and contributors. Convene separate meetings of the company's creditors and contributors. Number four, appoint a qualified person to be a liquidator. Appoint a qualified person to be a liquidator. Number five is pay or stop payment of dividends. Pay or stop payment of dividends. Pay or stop payment of dividends. And the last, number six, is help the company to avoid liquidation if possible. Help the company to avoid liquidation if possible. So those are the powers that a receiver has. Sorry, today my voice is not very good, so may not explain a lot. But you're saying that he should investigate why has this company failed? Why is it not able to pay the liabilities that they fall due? And this investigation would also touch on the promotion. How was the company promoted? How did the company get to be formed? What decisions have been made? And how are the affairs of the company? So you get into a lot of details about that. Then he will hold a separate meeting for the creditors and the meeting for the contributors. Remember, when we discussed the topic of meetings, we say that the meeting of creditors and contributors is held so that they can discuss on what we call the arrangement, the settlement arrangement. They decide on who will be paid how much and when. Then he can also appoint someone who is qualified to act as a liquidator. But we have also said that it is one of his mandates to ensure that the company does not liquidate, or finally the company does not end. So if he could get a way of a turnaround, then that would be fine. And in case the directors had declared dividends by the time he was appointed and they have not been paid, then he has the powers to pay those dividends, or he has powers to say, although the dividends have been declared, I am not going to pay. Now look at November 2020, question 5A. November 2020, question 5A. November 2020, Question 5A. Unasema aje?
Describe the power of use of
How many marks? How many marks?
3 marks.
3 marks. So we are told to describe the powers and duties of an official receiver, and we are given 3 marks. So that means they require a minimum of 3 points. I've given you 6. So that will be good. Let's now look at termination of receivership. Termination of receivership. When does it end? Termination of receivership. And we write that receivership is terminated. Receivership is terminated by discharge of the receiver. Is terminated by discharge of the receiver by a court. By a court. Once the reason for appointment is over. Is terminated by discharge of the receiver by a court once the reason for appointment is over. First, a receiver is not discharged until semicolon and point number 1. The receiver has had. The receiver has had any opportunity to prepare. Any opportunity to prepare and present his accounts. Present his accounts and final report. And final report relating to finally closing the receivership. Relating to finally closing the receivership. Closing the receivership. Number 2, the property is taken from the receiver's possession by the court. The property is taken from the receiver's possession by the court. And number 3, the receiver's liability as to the property is determined. The receiver's liability as to the property is determined. So what we mean by that is the court could have discharged. The court could have said the reason is over. But it's not over until this guy has prepared and submitted his accounts and his report regarding the coming to an end of the receivership. He must prepare and submit that report. And then it is not over until the court has taken over now the company or any property that this guy was in charge. It is not supposed to be left in his hands. And number 3, we should also determine whether he has any liability. Maybe when we made him to be in charge of our business, he incurred some liabilities which should be attributed to him. So we need to establish whether there is any liability. So that is all about receivership. Let's proceed now and look at administration. Let's look at administration. administration. And we write that this is a formal insolvency process. This is a formal insolvency process. Designed to rescue viable elements of a struggling business. Designed to rescue viable elements of a struggling business. Or else increase returns. For outstanding creditors. First up, the main objectives of administration are number one, maintain the company as a going concern. Number two, achieve a better outcome. For the creditors than would be the case in liquidation. Number three, realize the property of the company. In order to make a distribution. To secured or preferential creditors. A distribution to secured or preferential creditors. So here we are talking of a formal insolvency process, and we are saying an administrator, he comes in to try and rescue some viable elements of the business. For example, if this business has been having, you see, like, let me use the case of Destiny. Destiny, we have been teaching CPA, and we have also been teaching ATB. That's a minute. So I was saying, like, now here we teach CPA and we teach ATP. So if ATDs are struggling and CPA is doing well, you come in and try to rescue that which is doing well. And you also try to make a good return for the creditors, as opposed to what would happen if we allow this business to go to liquidation kufunga. So once the business is closed, the creditors may achieve very little. Yeah. Let's look at conditions for administration. Conditions for administration. Conditions for administration. One is business has become insolvent. Business has become insolvent. It's become insolvent. And cash flows and profits. And cash flows and profits cannot be reasonably predicted. And cash flow and profits cannot be reasonably predicted. Number two, pressure from creditors is mounting. Pressure from creditors is mounting. And there is a likelihood the company will be sued. There is a likelihood that the company will be sued. Number three is that the company has very little assets and cash flows. The company has very little assets and cash flows. So when you see those three things in a company, the company needs to be recommended for administration. We are saying that you are becoming insolvent. When you say you are insolvent, it means that your liabilities are more than your assets. What you own is more than or is less than what you owe other persons. That's when we say you are insolvent. And at that point, it becomes difficult to predict the cash flows and even then the profits. You see, when you can be able to predict the cash flows, you can make an arrangement with those people who are who you owe money. You tell them, where by end of March, I will have cleared your debt. You by end of April, by end of May, because you can see how your cash flows will come in. But if they are not predictable, you don't know when you will get the money. And these guys are there. Actually, point number two, we have said the pressure from creditors is mounting, increasing day by day. And from the look of things, these guys have started threatening, taking us to court. If they now sue us, they can get what we call the creditors liquidation. And again, at that point, we also realize that our assets are too little. Cash flows are too low compared with the liabilities. Appointment of an administrator. Let's look at appointment of an administrator. Appointment of an administrator. And we write that a person may be appointed an administrator. A person may be appointed an administrator by semicolon, point number one, a court order of administration. A court order of administration. Number two, holder of a floating charge. Holder of a floating charge. And number three, company or its directors. Company or its directors. Okay, then down there we write that an administrator An administrator is an officer of the court. An administrator is an officer of the court, whether appointed by the court or not. Whether appointed by the court or not. Whether appointed by the court or not. Another point is that an administrator must be unauthorized. An administrator must be an authorized insolvency practitioner. Authorized insolvency practitioner. First of all, a person cannot be appointed an administrator. A person cannot be appointed an administrator. An administrator in respect of banking, finance and insurance companies. Banking, finance and insurance companies. Stop. An application to the court. An application to the court for an administration order. For an administration order can be made by the following persons. Can be made by the following persons. Number one. The company. The company. Number two, the directors of the company. The directors of the company. Maybe you could be wondering what the difference between directors and the company. When you talk of the company, we are talking of an annual general meeting. Members have come and they have approved. Yeah. But when you talk about the directors, it is directors themselves. They have not involved the members. But when members are involved and they vote, that's now when we are saying the company, because members are the company. Number three is one or more creditors of the company. One or more creditors of the company. Number four, a combination of the company, directors and creditors. So that means they can combine either two of them or three of them. They can combine. Number five is any other person of a class prescribed by the insolvency regulations. The insolvency regulations. We have what we are calling the insolvency regulations, the rules or the act. So those acts, they also specify any other person that can apply for an administration Okay, another sentence now down there, we write that a company or its directors, may not appoint an administrator. May not appoint an administrator if an semicolon 1. If an semicolon 1. And rather application for the liquidation. Application for the liquidation of the company has been presented and is not yet disposed of. Number 2, application for administration. Application for administration has been made and is not yet disposed of. Number 3, administrative receiver of the company is in office. Administrative receiver of the company is in the office. So we are saying that you cannot be allowed to apply for administration if already someone has applied for liquidation of the company and the court has not yet finalized on that case. And someone has already applied for another administration. Remember, you have said it could be the company, it could be the director, it could be the creditor. So if someone has already gone ahead of you, you cannot be allowed to bring another one. Yeah. The other one is if there is already an admin in the office, if someone is already doing the job, you cannot apply again. Look at May 2016, question 7A. May 2016, question 7A. May 2016, question 7A.
Identify the person, third person who might apply for liquidation.
5 persons who might apply to court for liquidation of a company or the administration. So those are the 5 persons that we have said. It could be the company, it could be the directors, it could be the creditors, it could be any combination or any other person. Okay, let's look at powers of administrators. Powers of administrators. Powers of administrators. Number 1, take possession of. Take possession of. Comma, correct. This one. Correct. And get in the property of the company. And get in the property of the company. Number 2 is sell or otherwise dispose of. Sell or otherwise dispose of. dispose of the property of the company, by public auction, or private contract, by public auction or private contract. Number 3, borrow money for the beneficial. Borrow money for the beneficial realization. Borrow money for the beneficial realization of the company's assets. And to give security over those assets. Number 4 is appoint an advocate. Appoint an advocate or an accountant. Or any other professional. To assist the administrator in his duties. Number 5, bring or defend any action. Or other proceedings. In the name and on behalf of the company. Another one is refer to arbitration. Any question affecting the company. Another one is maintain insurance policies in the company. So limesema maintain insurance policies in the company. Number 8 is use the company's seal. Use the company's seal. Use the company's seal. Number 9 is change location of the registered office. Change location of the registered office. And number 10 is carry on the business of the company. 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 So there is this question of December 2022, question 4C. December 2022, question 4C. Nasema?
Someone is the following information from station. We are giving you some administration. To make us also an example of the bishop to the administration of the 3 highlight 4 hours exercise administration appointed.
Okay, so the question is threefold. The last point they're asking powers. So we have listed those powers, 10 of them. Then they have asked, number 2, they have asked the persons who are qualified to apply for the liquidation, the administrator. We have given 5 of them, and then we have also been asked to state the objectives. And we had stated earlier the 3 objectives of administration. From there, let's look at process of administration. Process of administration. Process of administration. Process of administration. Number 1. The administrator sets a notice of appointment. The administrator sets a notice of appointment to the company. And publishes it. And publish it in such publications. Publish it in such publications and locations as required. And locations as required by insolvency regulations. as required by insolvency regulations. Number 2, the administrator obtains a list. The administrator obtains a list of the company's creditors. A list of the company's creditors and sends them a notice of appointment. And sends them a notice of appointment. Number 3 is that the administrator lodges with the registrar. The administrator lodges with the registrar the notice for appointment. The notice for appointment within 7 days. Appointment within 7 days. Number 4, within 14 days. Within 14 days, the administrator sends notice. Within 14 days, the administrator sends notice of appointment. Sends notice of appointment to such classes of persons. To such classes of persons as required by insolvency regulations. Classes of persons as required by insolvency regulations. Number 5, relevant persons provide the administrator. Relevant persons provide the administrator with a statement of the company's affairs. With a statement of the company's affairs within 12 days of receiving the request. Within 12 days. Within 12 days of receiving the request. Within 12 days of receiving the request. Number 6 is that the administrator makes a statement. The administrator makes a statement setting out proposals. The administrator makes a statement setting out proposals for achieving the purpose of administration. For achieving the purpose of administration. Number 7 is that the administrator convenes initial creditors meeting. Okay, then down there as an independent sentence, you write that the office of an administrator, the office of an administrator can become vacant. the office of an administrator can become vacant by the following ways. By the following ways. One, ceasing to be qualified. Ceasing to be qualified. Now let's do my prayer. Ceasing to be qualified. Ceasing to be qualified. Number two, removal by the appointing authority. Removal by the appointing authority. Number three is resignation. Resignation. Resignation on grounds such as ill health. Resignation on grounds such as ill health. Ill health. Conflict of interest. Conflict of interest. Intention to cease practice. Intention to cease practice. etc. And the last point is death. Death. Should be number 4, eh? Death. So the office, rather the process of the administration, that is how it goes about. So once you have been appointed by the court, you are supposed to send a notice of appointment to the company, telling them that from today, I've been appointed your administrator by this court for these purposes. Then from there, you also request the company to give you a list of their creditors. And once you get the list of the creditors, you send them the notice. You tell them that from today, I've been appointed an administrator of this company. From there, within 7 days, you should notify the registrar of companies that you have been appointed again as an admin. And within 14 days, you should set the notice of appointment to such classes of persons who are required to be sent the notification by the insolvency regulations. So again, if you look at those regulations, which are not part of our syllabus, you'll find that there are persons that are not the company, not the creditors, who should be notified, not even the registrar, who should be notified of the appointment. Then you should make a request to the relevant persons to give you a statement showing the current position of the company. And after you make that request, within 12 days, those guys should furnish you with the statement. And remember, we say that an administrator is an officer of the court. And if it's an officer of the court, it means they have the full backing of law. They can come and arrest you. They can take you to a court of law in case they think you're not complying with their requests. And after that, you now call for the creditors meeting. But before the creditors meeting, you need to have given us a statement, the plan of action. How is it that you are going to do the objective that you have been appointed to do? And then you have the meeting with the creditors, you agree. Then we are saying that the office can become vacant if you become disqualified. Again, if you look at those regulations, they will tell you how someone can be disqualified in case the appointing authority has decided you are no longer capable or you're no longer fit to hold that position, or for whatever reasons you decide to resign or death comes, then that office becomes vacant. Let's now look at dissolution as the next thing. Dissolution. Dissolution, it's number 3 now. And we say that this means removing the name of the business. This means removing the name of the business from the official register, removing the name of the business from the official register. From the official register. That is making the company. That is making the company to cease to exist legally. Making the company to cease to exist legally. Another point is that the registrar has power to strike off. The registrar has power to strike off any company, to strike off any company not carrying on business, not carrying on business, or not in operation, not carrying on business or not in operation. Yeah, so that is all that we mean by dissolution. It is your name being removed from the list of companies in the registrar's office. Let's finally look at liquidation stroke winding up. Liquidation stroke winding up. And we write that this is the process that results. This is the process that results in the company ceasing to exist. That results in the company ceasing to exist. First of all, liquidation may be either voluntary, as requested by members, be either voluntary as requested by members, or involuntary, as ordered by a court, on application by creditors, is ordered by a court on application by creditors. Yeah, so when it is voluntary, we use the word winding up more. Kama ni nyinyi mnajitoa, we use the word winding up. But kama ni kutolewa, creditors have gone to court, then it is more liquidation. Another point is that a company is unable to pay its debts. A company is unable to pay its debts if the value of its assets, is less than the amount of its liabilities. Is less than the amount of its liabilities. Another point is that a company may be liquidated voluntarily. A company may be liquidated voluntarily when semicolon and point number 1. Point number 1, the period, if any, the period, if any, if any, as set by articles has expired. The period, if any, as set by the articles has expired. Number 2, any event occurs. Any event occurs on the occurrence of which the articles provide the solution. On the occurrence of which the articles provide the solution. Number 3, a resolution providing for the solution is passed. A resolution providing for the solution is passed. Yeah, that is those are 3 reasons why you can dissolve a company voluntarily. Just like marriages, I'm told there are some places where marriage is number 1, you agree to naoana for 5 years. So after 5 years, kila mtu njia yake. I don't know whether here in Kenya we have you ever heard of that? Here we marry for life, but I'm told in some countries, marriage is very, very contractual. You agree that we are coming together for 5 years or whatever period, and after that, everyone to part ways. So the same can happen with a company, or you agree that we are forming this company, but in the event of our togetherness, if this thing happened, maybe I find you have taken more money than you should have taken, or I find you have employed people that you should not have employed, or I find we are not making profits. And the articles provide that when such a thing happens, the only remedy is to dissolve. So if there is that one and that event takes place, then we just dissolve. And the third one, we are saying we go to a meeting, and for whatever other reason, we agree, we pass a resolution that let us wind up this thing. Let us bring this thing to an end. Another sentence that within 14 days, of passing the resolution, within 14 days of passing the resolution, the company shall publish a notice. The company shall publish a notice setting out the resolution semicolon and point number 1. Once in Kenya Gazette. Once in Kenya Gazette. Number 2. Once in at least 2. Once in at least 2 main circulating newspapers. At least 2 main circulating newspapers. And number 3, in the company's website, if there is. In the company's website, if there is. In the company's website, if there is. So we are saying once you pass the resolution, weke kwa Kenya Gazette, alafu weke kwa hizi magazeti kama Nation, Standard, those are the main ones, and even the Kenya People or the People Daily. And then kama mko na website, you put it there that we have passed the resolution that we are winding up. Another sentence is like this: when voluntary liquidation starts, semicolon and point number 1, the company shall cease to carry on its business. The company shall cease to carry on its business unless very beneficial to liquidation. Unless very beneficial to liquidation. And point number 2 is that the corporate powers and status, the corporate powers and status of the company remain. What we mean by that is that the moment we want to do liquidation, immediately you stop undertaking any business and you start now engaging on liquidation. Nonetheless, that business that you are doing is very, very important for liquidation. The other thing is that although you have begun liquidation, your status, your powers still remain. What we mean by that is the characters of a company. The characters that the company is an artificial person, the company can join contracts, the company can sue or can be sued, and all those characteristics of the company, they still remain. It is only after the company has been dissolved or the dissolution has taken place that those status and power cease. Another point is that down there, in a member's voluntary liquidation, the company in a general meeting shall appoint a liquidator. Company in a general meeting shall appoint a liquidator. So that was more of the voluntary liquidation. Let's now discuss right now about the involuntary, and write that involuntary or compulsory winding up, involuntary or compulsory winding up, is ordered for by the High Court. Is ordered for by the High Court under the following circumstances. Is ordered for by the High Court under the following circumstances. The following circumstances. 1. The company has failed to commence business within 1 year. Company has failed to commence business within 1 year. Number 2, the company has suspended business. Company has suspended business for more than 4 years for more than 4 years without legal justification. The company has suspended business for more than 4 years without legal justification. Number three is that the membership has fallen below the required minimum. It's fallen below the required minimum for a period greater than 6 months. Membership has fallen below the required minimum for a period greater than 6 months. For a period greater than 6 months. Another one is that the company has failed to file a statutory report. The company has failed to file a statutory report. Another point is that the company is unable to pay its debts. The company is unable to pay its debts. Number 6, under just and equitable grounds, under just and equitable grounds, just and equitable grounds, such as semicolon and Roman 1. Roman 1, deadlock between shareholders. Deadlock between shareholders. Number 2, Roman 2, mismanagement of the company. Mismanagement of the company. Another one is excluding the proposed petitioner. Excluding the proposed petitioner from management. Excluding the proposed petitioner from management. Roman 4, breakdown in mutual trust and confidence. Breakdown in mutual trust and confidence. So we are saying that the court can order for a compulsory winding up or liquidation on those 6 grounds, or actually 9. One is the company was formed, but within 1 year they have not begun business. Or the company began business, but down the line they have suspended business for a period greater than 4 years. And they have not given any legal justification. The other one is that the membership of the company has fallen below the minimum, and they have stayed for more than 6 months. Remember, we said that once you go below the minimum, you are given a leeway of 6 months to make your house in order. After that, the company can be dissolved, and actually we said when we looked at that, that even the liabilities now become possible. The other thing is you have begun business, but you have not filed what we call the statutory report. Remember, we said that is the report that should be discussed in the statutory meeting, which is supposed to be held not earlier than 1 month and not after 3 months of the formation of the company. And then the company is unable to pay debts. I think sometimes back we give the characteristics when the company is not able to pay debts, and then at what we are calling just and equitable grounds, when you're looking for justice, when you're looking for equity, in cases where members cannot agree, there is a deadlock. There is a very clear evidence that there has been mismanagement of the assets of the company, and in a situation where someone in management has said they are going to apply for administration, and in response, the other members, they exclude him from the meeting, from the management. He's no longer invited for the meetings. He's no longer given notices and reports. So that will make the court to come and wind up the company. And in case there is breakdown in trust and confidence, particularly with the directors, you need to bring it down. Remember we said the other day that business cannot be done in mistrust. Remember, business is a form of relationship, and there is no relationship that can be run on mistrust. I hope we know that, including the relationship I have with you. I hope you know I have a relationship with you, teacher, student. You must trust me, I must also trust you for that relationship to be sustainable. So the same happens in business, because if you are in partnership with a person, not only partnership, even when you have employed a person, you cannot monitor them 24/7. And if you can, there is no need of having them. Instead of monitoring them, you can do what they are supposed to be doing. So there are times that people will be on their own, but you hope that they are doing something good for you. Yeah. I keep on saying, like now, those of us who are married, right now, my wife does not or cannot confirm that I'm actually in class. She's only hoping that I'm in class. And she cannot keep on following me everywhere I go to confirm that I'm in class. Equally, I also cannot keep on following her to know that whatever she told me she's going, that is where she is. There must be trust. So the same thing when you're in business, you must believe that hachukui pesa akiweka kwa mfuko. Mmoja atatumwa sokoni kununua some items. You must believe that ile bei amekuja kuambia ni hiyo. Yeah. Not unless there is very clear evidence that there is something that is not right. Another point is this, that after the court has issued a winding up order, after the court has issued a winding up order, after the court has issued a winding up order, semicolon in point number 1, no proceeding shall proceed. No proceeding shall proceed or commence against the company. No proceeding shall proceed or commence against the company. Number 2, no person may attach. No person may attach or otherwise appropriate. No person may attach or otherwise appropriate the assets of the company, or otherwise appropriate the assets of the company. Another one is that any disposition of company's property and shares is void. Disposition of company's property and shares is void. It's void. And the last point is any alteration in the status in the status of the company's members is void. Any alteration in the status of the company's members is void. So there's this question of September 2021, question 6B. September 2021, question 6B. Wasema?
With reference to liquidation of companies, the comes from liquidation about the less than liquidations.
Okay. Grounds for liquidation under what? Just and what? Equitable grounds. I think we have just stated those ones, eh? Yeah, summarize 3 consequences. So the consequences tumesema, kama kuna case ilikuwa inaendelea, immediately it stops. And you cannot start another case. It's not like the case of voluntary. Voluntary tumesema the state has remained, eh? So you can be sued or sue. But here, everything stops. And then we are saying no person can deal with the asset of the company in whichever order, can appropriate in any way. And in case number 3, we are saying in case someone disposes, someone sells the asset of the company, that sale is null and void. And you cannot purport to change the status of the company. Remember, sometimes in our earlier topics, I think we discussed the changing of the status of the company, how you can convert from this to this. Now, in that case, you cannot do it. And if you purport to do it, it will be declared null and void. Another point down there is that once appointed, the liquidator has the following powers. The liquidator has the following powers. 1, verify all claims. Verify all claims of creditors and consolidate them. Verify all claims of creditors and verify them. And consolidate them. Verify all claims of creditors and consolidate them. Number 2, take in custody or control. Take in custody or control of all creditors and consolidate them. Sorry. Let me repeat that point. Take into custody or control of all assets of the company. Custody or control of all assets of the company. Number 3, evaluate assets of the company and make a report. Evaluate assets of the company and make a report. Evaluate assets of the company and make a report. Next is take measures to protect assets of the company. Take measures to protect assets of the company. Number 5 is carry on the business. Carry on the business. If beneficial to liquidation. is beneficial to liquidation. Number 6 is sell properties of the company. Sell properties of the company. Okay, another sentence on its own reads like this: the powers of a liquidator will be terminated on the following grounds. The powers of a liquidator will be terminated on the following grounds. One is bankruptcy. 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 Number 2 is unsound mind. Unsound mind. Number 3 is death. Number 4 is resignation. Number 5 is becoming disqualified. Becoming disqualified. And the last one is completion of liquidation process. Completion of liquidation process. Okay, then another sentence. The cash received from sale of company assets. The cash received. The cash received from sale of company assets. Sale of company assets shall be paid out in the following order. Shall be paid out in the following order. Number 1. All government and authorities. All government and authorities. Rates payable within a year. Authorities rates payable within a year. Two, all government and authorities rates. All government and authorities rates in arrears more than 1 year. In arrears more than 1 year. Another one is number 3, wages and salaries rendered. Wages and salaries rendered. Rendered within 4 months before winding up. Within 4 months before winding up. Number 4 is all secured creditors. All secured creditors. All secured creditors. Number 5 is all unsecured creditors. All unsecured creditors. Number 6 is holders of preference shares. Holders of preference shares. Next is holders of ordinary shares. Holders of ordinary shares. And the last one is promoters of the company. Promoters of the company. So you see, when you get any money from the liquidation, the government comes in first. And we are talking of all government and authorities. These words were coined in those days when we used to have the local authorities, the councils, the municipal councils. But since 2010, they have been replaced with county governments. Yeah, so that means now in today's reality, we would say the central government and the county government. Yeah, the central government and the county government. If you have any rate for them, remember rate is the amount of money you pay for holding land within a municipality. And I heard they are going to introduce even now in the villages, start paying the fee. Are you aware of that? Yeah, you know, in the villages, there is what property in Kenya is divided into two. Leasehold. Leasehold are all the plots that are within municipality. Na hizo ndio huwa zinalipiwa rate per year. Kila mwaka lazima ulipe. Na ikifika mahali, the government can come and take over. That's why you always hear the governors give waivers, ask people to come and pay, and so on. Then we have what we call the freehold. Freehold. Now, freehold, it is any land you hold out of the municipality, out of town. Like now in our villages, so mashamba zetu, they are freehold. There is no single time the government will come and tell us to pay something. But I think there is an intention that now everyone shall be paying for the rates, yeah, which somehow it could be good or somehow it could be bad. The good with it is they want to discourage these people who hold a lot of land, which is not being used, and there are others who are struggling, they are squatters. So the objective is to ensure kila mtu amehold shamba yenye anaweza kulipia. Kama huwezi lipia, peane, na wengine wako na shida. But on the other side now, wale hawawezi lipia hizo rates, what do you do with them? Unanyang'anya ama utafanya nini? Unanyang'anya. They should not hold in the land. Okay, look at November 2019, question 7A. November 2019, question 7A. Okay, so we are told to give powers of a liquidator. I think we gave 6 powers, and then hiyo ingine tumeambiwa grounds for compulsory liquidation, we also gave 6 of them. I think that is good. Haya, angalia here, May 2016, question 7B. May 2016, question 7B. May 2016, question 7B, nasema.
Describe how ways in which manipulate to distribute the assets of the company.
Yeah. 5 ways in which the money could be distributed. I think we have given 8 ways, the order. You do order. Lazima zifuatane hivyo. So we then call it a day at that point. Tomorrow I don't intend to meet you because I only have 3 more pages remaining. So I want to take them to next week on Monday. So tomorrow we shall not have a company law class. We shall meet on Monday next week to wind up the syllabus. And then to agree kama tutachukua leave ya 1 or 2 days before we start the revision. Yeah, see, that's okay. Yeah, so tomorrow we are not meeting. We meet on Monday next week. God willing. Thank you.